Hello friends, in this part we shall understand various provisions related with the contract of agency. First of all, we shall understand certain basic concepts related with the law of agency. Then we will discuss what are various modes of creating agency. Then we shall understand what is the extent of an agent's authority, what are duties and obligations of an agent, what are rights of an agent, and finally we shall discuss how an agency can be terminated. Let's start with certain basic concepts of law of agency. Section 182 of the Contract Act gives us two basic definitions related with the contract of agency. The first is agent. What do we mean by an agent? The law says agent is a person employed to do any act for another or to represent another in dealings with third parties. So basically, agent is a person who has been employed by somebody else for doing something on behalf of that somebody else or to represent that somebody else in a dealing with third parties. Related with the agent, there is a concept of principal. Now very simply, principal is the person for whom such act is being done or who is being so represented. So person who is representing somebody else, he is called agent. The person who is being represented, he is called principal. The very basic rule of law of agency is that for any act done by the agent, the principal is treated as responsible as if the act has been done by the principal himself. Though the principal is getting the act done through an agent, but whatever shall be done by the agent, it shall be treated as if it has been done by the principal himself, and accordingly the principal shall only be responsible for whatever has been done by the agent. Now the question comes, who can appoint agent? As we can see, section 183 is giving us that concept and mentioning that any person who has got two qualities, one who has attained the age of majority and second who is of sound mind, this person can appoint another person as his agent. And then another very important rule related with the contract of agency is given by section 185, which says very simply that no consideration is necessary for the contract of agency. This in fact is an exception to the basic rule of the Contract Act that normally a contract without consideration is void, but a contract of agency can be a contract for which no consideration is necessary. After understanding some very basic initial rules related with the contract of agency, now let's discuss what are the various modes of creation of agency, in how many ways a contract of agency can be created. There are 5 different ways through which a contract of agency can come into existence. The first is agency by express authority. Next is agency by implied authority. And here also there are two different possibilities. One is agency by what is called estoppel, and second is agency by holding out. Then there is something called agency in case of emergency, agency in case of necessity, agency by ratification, and finally agency by operation of law. So these are 5 different modes through which a contract of agency can be created. In next few slides, we will be discussing each of these modes in little bit detail. The first is agency by express authority. Now this is the most obvious way of creating a contract of agency, where one person is expressly appointing somebody else to do something on his behalf. The obvious example, Mr. A residing in Delhi, having a house at Kolkata. He appoints B in Kolkata as a caretaker of his house by a power of attorney. Now A has appointed B as agent of A by way of an express authority. The next way through which a contract of agency comes into existence is what is called by way of implied or ostensible authority. Here, there is no express arrangement amongst the parties for the contract of agency, but the agency gets created by the conduct of the parties. The first such possibility is by agency through estoppel. Now, this is a concept where one person allows another to act on his behalf in such a manner that a third reasonable person would believe that there is a relationship between principle of agent between first and second person, and in such case the first person would be stopped from denying that he is not appointed second person as his agent. Here, the first and second person through their conduct are conveying a message to the third party that they are having a relationship of principal and agent. Let's try to get a further clarity on the concept by way of an example. Mr. Raju informs Hari in the presence of Kishan that Kishan is Raju's agent. When Raju is informing this through Hari, Kishan is also present and Raju is saying to Mr. Hari that Kishan is my agent. Later on, Hari enters into a contract with Kishan, thinking that Kishan is an agent of Raju. In this case, Raju and Kishan through their conduct have conveyed this message to Hari that Kishan is agent of Raju, and that's why neither Mr. Raju nor Mr. Kishan can later on refuse the obligations under the contract. This creates an agency by estoppel. Another type of agency by implied authority is agency by holding out. This concept says that if any person holds himself out as an agent of another, he declares to public at large that he is agent of somebody else, and that somebody else does not deny it, then also a relationship of agent and principal gets created. If somebody says that he is an agent of yours and you do not deny it, the law assumes that there is a relationship of agent and principal gets created between you and that third person. Another way of creating a contract of agency is agency in case of necessity or agency in case of emergency. This is a situation where the agency is getting created due to circumstances. Sometimes circumstances may create a relationship of agent and principal. Let's understand it with a very simple example. A horse has been sent by rail, but it has not been taken delivery by the owner at destination. The station master was required to feed the house. The law says, in this situation, circumstances have created a relationship of agent and principal between station master and the owner of that horse, and now the owner shall be required to compensate the station master for whatever expenditure has been incurred by him. This is an agency in case of emergency. Another way of creating agency is given by section 196 of the Contract Act, which is called agency by ratification. Here, the section says that when one person does something on behalf of another without the knowledge of another, that another is having an option either to ratify the work done by the first person or disown this work done by that first person. However, if this second person decides to ratify the work done by first person, now a contract of agency has been created between first person and second person. The first person shall be treated as agent of that second, and second shall be bound to compensate the first. Say for example, A without authority buys goods for B. Later on, B sells these goods to C. Here, the B's conduct has implied that he has ratified the purchase made by A, and a contract of agency has come into existence between A and B by ratification. And finally, in some cases, agency gets created by operation of law also. In certain circumstances, it is law which creates a relationship of agent and principal. The very obvious example is partners and partnership firm. As per law, partners are considered as agents of each other and also the agents of the firm. So this is agency which is getting created by operation of law. After discussing various modes through which a contract of agency can be created, now let's try to understand another issue, that is, what is the extent of the authority of an agent. The law discusses the extent of agent's authority in two different circumstances. First, authority of agent in normal circumstances, and second, what is the authority of an agent in case of emergencies. Let's discuss these concepts in next slides. First of all, what is the authority of an agent in normal circumstances? Section 188 gives a very important provision in this regard and says that where an agent is having an authority to do any act, he has authority to do every lawful things also which is necessary to do the original act. So the point is, agent has been appointed to do a particular act. He has been given an authority to do any particular act. The law says, in order to do the main act, whatever lawful things are required, agent shall be having an authority to do all those lawful things. The key point is, whatever is being done by agent, that should be a lawful thing. Say for example, Mr. A has employed Mr. B to recover a date due. Now, Mr. A may adopt any legal process which is necessary for recovery of that date. He has been appointed only to recover the date, and he can take all the legal processes which are required for recovery of this date. This is what is the authority of an agent under normal circumstances. As an extension of earlier concept, the section also says that if an agent has been given authority to carry on a business, he shall be having an authority to do every lawful thing necessary for the purpose of that business and to do all those things which are usually done in the course of conducting that business. Say for example, A has appointed B as his agent to carry on the business of a shipbuilder. Now Mr. B may purchase timber and other materials. He may also hire workmen for the purpose of carrying on the business. He has been given an authority to carry on the business, and in this case he can do all the things which are necessary for the purpose of business, which are usually done in the course of conducting such business. After discussing authority of an agent under normal circumstances, Section 189 discusses the authority of an agent in case of an emergency. The law says that in case of an emergency, an agent has authority to do all such acts for the purpose of protecting the principal from loss, which are done by any normal person, any person of ordinary prudence in his own case under similar circumstances. So if there is an emergency, the agent shall be having authority to do all the acts which are done by a normal person under the similar circumstances, the idea being protecting the principal from loss. A very simple example: an agent for sale may get goods repaired if it becomes necessary. Goods have become damaged, he shall have an authority to get those goods repaired. This is the authority of an agent in case of emergency. Section 229 of the Act covers the matter of notice given to an agent. Section says that if any notice has been given to the agent or any information has been obtained by the agent, it shall be deemed as if this notice has been given or this information has been obtained by the principal himself. So, when an agent enters into negotiation with a client, it is considered that principal is aware of the fact, he is aware of all the negotiations which are happening between agent and the client. And now let's discuss some very important provisions related with the duties and obligations of an agent. First of all, what is the duty of an agent in the conducting business of the principal? Section 211 provides the answer, and it says that an agent is bound to conduct the business of his principal as per the directions given by the principal. However, what will happen if no clear directions are available from the principal? The section further provides, if there are no such directions, then agent is required to carry on the business in accordance with the prevailing customs in respect of that particular business. And then, what will happen if the agent acts otherwise? Section further says, if any loss has occurred, the agent is required to make this loss good to the principal. However, if any profit accrues, he must give that profit back to the principal. He must account for that profit to the principal. Say for example, B is an agent in a business where the sale is only on cash. It is not customary to sell on credit. However, agent sells goods of A on credit to C. At the time of sale, the credit of C was very high. However, before making the payment, C becomes insolvent. Now here B, the agent, has not acted as per the customs of the business, and that's why he is required to make good this loss to his principal, that is Mr. A. Section 212 talks about skills and diligence required from an agent. Section says that every agent is required to use general skills for carrying on that particular business, as much skill as is generally possessed by the persons who are engaged in similar line of business. If he doesn't use this general level of skill, then if any loss has been suffered by the principal due to lack of skill from the agent shall be liable to compensate this loss to the principal. Say for example, Mr. A, an agent, has been authorized to sell the goods on credit. He sells these goods to a customer B without making the normal inquiry regarding solvency of the customer. At the time of sale itself, this customer was insolvent. Here, the agent has not used the normal skills required in the business, and as such, whatever loss has occurred to the principal, agent shall be liable to compensate for this to the principal. Section 213 creates one more duty for the agent by saying that agent is required to give proper accounts to his principal on demand. Accounts of whatever expenditure he has incurred, accounts of whatever money he has received on behalf of principal. He is required to give proper accounts to the principal whenever demanded by the principal. Another duty of agent has been created by section 214 regarding communication with the principal. Section says that in case of any difficulty, it is duty of an agent to use all reasonable diligence, to use all reasonable means in order to communicate with his principal and to obtain his instructions. So if there is any difficulty, it will be duty of the agent to communicate with the principal and to get his directions as to what is to be done in that particular circumstances. For this communication, he should use all possible means, he should use all reasonable diligence. Section 216 discusses about a very important situation, that is, what will happen when an agent deals in his own account. Instead of dealing on account of principal, the agent deals on his own account. Section says that if without the knowledge of principal, the agent deals on his own account in the business of agency instead of dealing on behalf of principal, in such case, the principal is entitled to claim any benefit which has been accrued to the agent from this transaction. So agent must make good all those things which we have get out of the transaction to the principal if he has dealt in a case on his own account instead of dealing on account of principal. See for example, Mr. A has directed his agent to buy a particular house. Agent tells to Mr. A that house is not available, and later on he buys the house for himself. Later on, when principal comes to know about this, he may compel the agent to sell the house to the principal at the price what has been decided by the principal. After discussing various duties of an agent, now let's talk about rights of an agent. The first right of an agent is right to be indemnified against consequences of any lawful acts done by the agent. Section 222 discusses this concept further and says that the employer, the principal of the agent, is bound to indemnify the agent in respect of any lawful acts which have been done by the agent in exercise of the authority given to him. So if within the limit of authority, agent has done any of the lawful acts, the employer, the principal, shall be required to indemnify the agent against the consequences of all such lawful acts. Say for example, Mr. B, an agent, under instructions from his principal, has contracted to sell certain goods to a third party C. Principal has not sent those goods to the agent, and that's why agent couldn't deliver those goods to the customer. The customer, Mr. C, has filed a suit on agent for breach of contract. B has informed this fact to the principal, and principal A has authorized the agent B to defend the suit. B defends the suit and is required to pay damages and has incurred expenditure in defending that suit. All this thing has been done by the agent within the limit of his authority. These all are lawful acts done by him, and as such, Section 222 shall be applicable in this situation. The principal, Mr. A, is liable to B for all such damages and expenditure. Section 223 talks about a situation where agent has done something in good faith, and the law says, again, agent has a right to be indemnified against consequences of all those acts which have been done by him in good faith. Let's elaborate the concept further. Section says that when one person employs another to do an act, when the principal appoints an agent, and the agent does that act in good faith, the principal, the liable to indemnify the agent against the consequences of all those acts, even if because of the act of the agent an injury has caused to the third party. So the whole idea is this: employer has asked the agent to do something, agent does this in good faith. Because of this act of agent, an injury has caused to third party, but here the employer shall be liable to indemnify the agent in respect of all the acts which have been done in good faith by the agent. Let's take another example. The agent sells goods in possession of his principal. However, principal was not having any legal right to sell those goods. The agent, Mr. B, is not aware of this fact, and he simply hands over the sale proceeds to the principal, Mr. A. He has done this whole act in good faith. Later on, the real owner of the goods, Mr. C, files a court case on the agent, Mr. B, and recovers the value of goods from the agent. Now here, the principal A is liable to indemnify the agent B for whatever amount he is required to pay to third party C, and for agent's own expenses. The agent has acted in good faith in this situation, and that's why principal shall be liable to compensate the agent. In respect of right of agent to be indemnified, a very important exception has been created by Section 224, which says that agent does not have any right to be indemnified in respect of any criminal acts. Section says that where one person appoints another to do any act which is criminal in nature, then the agent shall not be entitled, the employer, the principal shall not be liable to indemnify the agent against the consequences of that act. The act which agent has been asked to do was criminal. Agent performs that particular act. Whatever consequences of that criminal act, agent must bear those consequences himself. Employer shall not be liable to indemnify the agent in that respect. A very simple example is Mr. A appoints Mr. B to beat C and agrees to indemnify him against all the consequences of the act. B thereupon beats Mr. C, and then he is required to pay damages to Mr. C for doing so. B cannot claim any amount from Mr. A. B is not entitled to be indemnified by his principal because the act which has been done by B was criminal in nature. After right of indemnity, Section 217 gives us the provision regarding right of retention of an agent. Section says that any sum which has been received by the agent on account of principal in the business of agency, he may retain out of these sums two types of monies due to him. First, any money which is due to him in respect of expenditure incurred by him, advances made by him in conducting the business of agency. And second, he can also retain any remuneration which is due to him. So out of the money belonging to principal, agent can retain these two types of money. This is an express right given to him under section 217. Section 221 talks about right of lien of an agent. Section says that unless there is any contract to the contrary, the agent shall be entitled to retain whatever he receives on behalf of principal. It may be goods, it may be papers, it may be any other movable or immovable property belonging to the principal and which has been received by him in the course of agency business. The agent shall be entitled to retain all those things unless and until whatever amounts due to him are paid to him. This amounts may be on account of commission, on account of expenditure incurred by him. He may retain the goods, papers and other property of the principal until all these amounts are paid to the agent. This is called right of lien of an agent. And now let's discuss the idea how an agency gets terminated, how an agency comes to an end. There are 5 different modes through which an agency gets terminated, and these are where the principal revokes the authority given to the agent, where the agent renounces the business of agency, he denies to carry on the business of agency further, where the agency business gets completed, the business for which agency contract has been created, that business is over, the agency gets terminated. Fourth situation, either the principal or the agent dies or become of an unsound mind person. In that case also agency gets terminated. And finally, where the principal has been adjudicated as an insolvent, this will also result in termination of contract of agency. This completes our discussion regarding contract of agency. Let's summarize whatever we have discussed in this part. The very basic principle of contract of agency is that for any act of agent, the principal is responsible as if this act has been done by the principal himself. Whatever has been done by the agent is considered to be done by the principal. No consideration is necessary for a contract of agency. An agency may get created either by way of an express authority given by the principal, or there may be an implied authority for creation of contract of agency. The contract of agency comes into existence in case of necessity. The agency may get created by ratification also, and in certain circumstances it is law which creates a contract of agency between different persons. The law says that if an agent has been given an authority to do any particular act, he shall have authority to do all the lawful things which are necessary for performing the main act. The Contract Act provides for various duties of the agent while he is conducting the business of principal, and similarly various rights have also been given to the agent in respect of his dealings for the principal. Thank you.